The next person that you're going to hear from, welcome back to those that were with us the first 2 years, and welcome to those that are here for the first time. Stick with us if you can. Each Monday night we will get started at 6:30, and hopefully the parking situation will be worked out and everyone can get in fairly smoothly, and we can get things rolling, and we can just make this a great, engaging and educational program for everyone that wants to participate. But the next person you're going to hear from, and did we want to, I saw another person. Introduce yourself. I'm so sorry.
Okay. I'm Russell McQuaid from Fox 59. I'm just here to see if they're going to tell me any secrets.
The next person I'll introduce is actually one of my neighbors in my hallway, and that is Deputy Prosecutor Tyler, and she will introduce our speakers for tonight. Kavana.
Good evening, everyone. As Andy said, I am a Deputy Prosecutor at the Prosecutor's Office, and I will be introducing our speakers for this evening. Prosecutor Terry and the Grand Jury Investigation Supervisor, Tom Gankars, will lead our discussion this evening on an inside look at the grand jury. Now, it will share insight into the grand jury process, as well as how the Prosecutor's Office utilizes the grand jury to investigate and prosecute cases. Now, during Prosecutor Curry's 6 years as a Deputy Prosecutor with the MCPO, he was responsible for prosecuting white-collar crime and political corruption, and served as a supervisor for the Grand Jury Division. He has been involved in multiple grand jury investigations since taking office in 2011, including the prosecution of Stacy Sheedy, an attorney and accountant who was sentenced in 2012 for stealing $596,000 from her elderly and disabled clients. Also, the other presenter, Tom Gankars, joined the MCPO in March after 25 years in the FBI. From 2007 to 2011, he served as Assistant Special Agent in charge of the Indianapolis FBI office. He has extensive experience investigating white-collar crime, fraud, and corruption. And now I present to you Prosecutor Terry Curry and Tom Gankars.
And I would add with Annie that welcome everyone, particularly those of you who have been here before. We've seen a lot of familiar faces who have been at our prior two sessions, and I first of all would promise you that the subsequent sessions over the course of this month will be a lot more interesting than me. I'm told that when we have the CSI function, actually the crime lab van will be here to be able to see that. So we have some interesting topics set up. And just to add to what Annie said in terms of our program and our outreach efforts, I sometimes start to sound like a broken record in that I say over and over and over to neighborhood associations, church groups, everyone that I have the opportunity to talk to, that we can't just count on our police department. We can't just count on the prosecutor's office to address public safety issues. It needs to be a community-wide effort involving the entire public and all of our public safety agencies. And so that's why we do this program, that's why we do other outreach programs, is to get you involved. And as I do every single year when we have this session, is not only come back next year, but bring 2 or 3 of your neighbors next year, because the more that we engage in this sort of collaborative effort, the better we're going to be able to address our public safety issues. So tonight we're going to talk about the grand jury. And first of all, I need to explain that the way we use this terminology sometimes gets confusing in the local state system, and I never really even focused on this until I thought about talking tonight, because in our office, and Tom's going to talk about our grand jury investigators, and Barbara's son, Sergeant Eads, is actually one of our investigators assigned to our office. We use the term all the time about grand jury investigators, but actually those sort of investigations really have nothing to do with the grand jury process itself. And I'm going to explain and try and delineate the two. Because when we talk about grand jury, on the one hand, a grand jury is a body of citizens which considers evidence to determine if charges should be filed against an individual. And I'm going to talk about some of the statutes that apply to the formulation of a grand jury, how the grand jury is how they hear evidence, and how they make a determination whether a charge should be filed. But in most instances, And when a charge is filed by a grand jury, it's called an indictment. Everyone's heard that term, an indictment. So if a person is going to be charged with a crime, they can be charged in the state of Indiana by one of two mechanisms. They can be charged by a grand jury indictment, at which point the grand jury of 6 folks that we're going to talk about determines that there's probable cause to believe that that person has committed a particular crime, and then returns an indictment charging that individual with a particular crime. But in Indiana, in state court, an individual can also be charged by what's called an information. And as probably some of you heard me say before, in Marion County last year we filed approximately 50,000 criminal cases. If we were to file all those cases by presenting the evidence to a grand jury and waiting for a grand jury to return, the whole system would bog down. So when we charge a crime, and I don't know the exact number, but it's easily got to be 99% of the time, we charge crimes by way of an information. And what that means is that the investigating officer, if it's someone from a detective from IMPD who's investigating a burglary, if he or she determines that they have sufficient information to believe that John Doe has committed that crime, they will put together a probable cause affidavit setting forth what they've learned in their investigation. They'll bring that to our office, and our screening department will determine whether in fact we believe there is sufficient probable cause to believe that this individual committed the crime and what that crime is, and we will prepare an information. The information and the probable cause affidavit will be submitted to a judge who will review it and determine and agree or not agree as whether there's probable cause. And if there is probable cause found by the court, that charge will be filed by way of an information. Again, in state court, probably 99% of the cases we file are by way of a probable cause affidavit and a charging information. However, we do present some cases to a grand jury, and so I'm going to talk a little bit about the grand jury. Before I do, the second half of our presentation will refer to what I call loosely the grand jury investigators. And we have 7 police officers currently assigned to our office full-time to investigate white-collar crime and other long-term investigations. And this has been done historically over the years, going back to another lifetime ago when I was a deputy prosecutor, which Kavana referred to, and I was assigned to the grand jury. And again, the terminology gets confusing because that's what we call it. It never occurred to me until I started preparing this, and maybe we should call it something else so it wouldn't be so confusing. But we have the investigators, and in most instances, those cases, again, are charged by way of a probable cause affidavit and information. And when we get to the second half of the presentation, we're going to talk about some of those cases, and Tom will talk about how it is that information comes to our office in the first instance, as opposed to going to, for example, IMPD or the state police, how the information gets to us, and how we initiate discrete investigations of political corruption, white-collar crime, and other long-term investigations. So let's talk a little bit about the grand jury itself, how it's formulated, and how they present the evidence. The court calls a grand jury into session at the request of our office. The jurors are impaneled for a grand jury using the procedure for regular juries. And what that means is summons are sent out. How many people have ever been called for jury duty? Okay, virtually everyone, me too. Anyone ever been summoned for jury duty and turns out that they are being summoned for possible seating on a grand jury? Anyone? Okay. Well, those of you who have been called for jury duty, the potential grand jurors are summoned in the same way. They receive the summons, they report to the court, and then those individuals come from the voter polls and BMV records, just like regular jurors. The grand jury itself consists of 6 grand jurors and 1 alternate. And the way those individuals are selected is the same process. Those of you who have been called for jury duty, the same way as you select for jury duty. There's a voir dire process where deputy prosecutors ask questions of the individuals in terms of their willingness and ability to sit, the ability to hear things and make a fair decision on any matters that are presented to them. And then they are selected much like a regular jury. Once the 6 grand jurors and 1 alternate are selected after being called in, the court itself, and we'll get back to the court, which is responsible for monitoring the grand jury from month to month, the court selects one individual as the foreperson and one person as the clerk of that grand jury. The grand jurors must be U.S. citizens, 18 years of age or higher, and Marion County residents. Russ, you can leave now, because grand jury matters are secret. And by statute, no person may, except within the lawful discharge of their duties upon written order of the court, disclose the nature or substance in grand jury testimony or any decision, result, or other matter. Yes, sir. And we'll take questions at the end as well. Yes, sir. Go ahead.
What's a foreperson?
The person who essentially directs the discussion. So if those of you have ever sat on a jury, in a regular jury, once the case is concluded, the jury will then retire to the jury room to deliberate, and the jury then will select among their own members a person who is the foreperson. And all that person is basically in charge to direct the conversation. And
Is the clerk also among those people?
right. And the clerk, in terms of a grand jury, the clerk is essentially someone who will sign off on the term. So the matters heard before a grand jury cannot be revealed by any of the grand jurors. It can't be revealed by the witnesses or anyone else who participates in the process. At the conclusion, we'll get back to the second, what a grand jury will determine if the matter's been presented, and we'll go back to that burglary and John Doe case. If that went to the grand jury would ultimately vote on it and either determine there's a no bill, meaning that they did not find probable cause, no charge, or they would find a true bill, which is an indictment, and therefore a charge. Now, having said all of that, if in the case of the burglary, John Doe was indicted for burglary, then first of all, the indictment itself would become public record. And secondly, once counsel entered an appearance for the defendant, Mr. Doe in that case, they would receive copies of the grand jury testimony and that sort of thing in the course of regular discovery that we would provide to the PD's office in any sort of case. And so ultimately that information is provided for purposes of going forward in the case. But otherwise, anyone who participates in the process is by statute forbidden from disclosing any of the information. We will occasionally present cases to the grand jury, and an example of the sort of case that we will present to a grand jury was the shooting which occurred in Broad Ripple in August. August 2nd, there was a shooting in Broad Ripple where an individual may or may not have been confronted by a number of individuals. It was late in the evening in Broad Ripple, and he fired some shots, and 4 individuals were shot there. And at the time, the suspect said he was being threatened by the individuals, and so there was a pretty significant question, whether the shooting would meet the legal standard of self-defense or not. And that's a perfect example of the sort of case where essentially we feel it's appropriate to present the evidence and then let 6 citizens, the grand jury, make a decision based upon that evidence. Where it's a close call. And essentially it gives our office a trial run to make a determination, is this case presentable or not presentable. There may very well be instances where individuals are not being cooperative in an investigation. And so that's another example of a case where we might present the case to a grand jury where we have the ability to subpoena the individual to the grand jury, elicit their testimony, and perhaps then have the ability to make a case that otherwise we couldn't make because of the lack of cooperation. I'm going to talk a little bit about special grand juries in a minute, but another mechanism that is available in the grand jury is to grant individuals immunity for their testimony that otherwise we wouldn't be able to do but for going through the grand jury process, where again, if an individual is not cooperative and we don't think that they're the suspect, we might grant them immunity for their testimony, meaning that they would not be prosecuted for anything they testified to in the course of the grand jury. So these are examples of things that we would do in a grand jury. Another mechanism that we have by presenting things to the grand jury is the grand jury has subpoena power. And so, does everyone know what I mean by a subpoena? We would get an order from the court for a subpoena for Russ McQuaid's bank records, for example, and gather evidence or information that otherwise might not be available through a normal investigation. So in the instance of the Broad Ripple shooting on August 2nd, the target of that investigation, in other words, the suspect's name was Tristan Creighton. And so the evidence, all the witnesses were summoned in and evidence was presented. I can't talk about what that evidence was, but what the final conclusion of the grand jury after hearing it was, they believed that Mr. Tristan did not act in self-defense and in fact indicted Mr. Tristan on several counts related to criminal recklessness and handgun violations. So in this instance, Mr. Creighton would have received a target subpoena, which we'll talk about, and he was the target or the subject of that particular grand jury investigation. As a target, if the target of any grand jury investigation receives, they will receive what's called a target subpoena, letting them know that they are in fact the subject of that grand jury investigation, and the subpoena must advise him or her that he's the subject of the grand jury investigation, has the right to consult with an attorney and be assisted by an attorney. If he cannot afford an attorney, the court impaneling the grand jury will appoint one for him upon request, and he is entitled to the assistance of his attorney in the grand jury room. So an attorney for a target in a grand jury investigation can actually sit in during the course of his client's testimony if his client testifies to the grand jury. The target has the right to refuse to testify, just like anyone who has the Fifth Amendment privilege. But if the target does testify, he or she can have their counsel present in the grand jury room during that testimony. However, the target's attorney must take an oath of secrecy. The target's attorney may not, without seeking approval from the prosecutor or the foreperson, address the grand jury or the prosecuting attorney. Unlike in a trial, the attorney for the target cannot make objections or arguments to the grand jury. The attorney cannot question any of the persons before the grand jury or otherwise participate in the proceedings. The attorney may advise his or her client in the body of the grand jury room as long as that advice is not overheard by the grand jurors. Yes, ma'am.
So, that attorney cannot use information that's revealed in the grand jury for his client's defense in the future?
Well, yes and no. First of all, he can only be present in the grand jury proceedings while his or her client is testifying. Okay, so he would not be present while any other witnesses testify. But then, if the grand jury returns an indictment, as I said earlier, then transcripts are prepared of the witness's testimony, and that would be provided to counsel, just like we would provide witness statements in any other case that's filed to counsel for the defendant in the course of normal discovery. So in order to have valid proceedings before the grand jury, 5 of the 6 grand jurors must be present. The court and prosecutor are the legal advisors for the grand jury. And I'm going to talk a little bit about that in a minute. But in terms of advising the grand jurors of what the law is, that would come solely from the court in the initial selection process, as well as from the prosecutor or deputy prosecuting attorneys who are conducting the proceedings in the course of any particular hearing. The prosecuting attorney and staff and any witnesses may be present any time during the proceedings except during deliberation. And deliberation, hold your thought there for a second, Mr. Boyd. And deliberation is solely what you would expect, and that is once all the evidence is presented, just like those of you who have been on jury duty, then everyone retires from the room other than the grand jurors, who then discuss the evidence they've heard and vote as to whether an indictment will be returned or not. And witnesses are subpoenaed to testify before the grand jury. Again, as I said, the grand jury has subpoena power to summon not only witnesses, but also to summon the production of documents, whether in particular bank records or that sort of thing. We're going to talk about some of the white-collar crime investigations in a minute. Before any grand jury deliberates, the prosecuting attorney must identify on the record each target of the investigation, who are the suspects, in each offense that each target is alleged to have committed. And, yeah, Mr. Boyd, I'm sorry, you had a question?
Why would not all 6 grand jurors be present, especially if you have an alternate, if one couldn't be there with the alternate?
Yeah, if the alternate would sit and vote if someone were absent. But the grand jury actually sits for 3 months at a time, actually could be longer. They're not there every day for 3 months. In fact, depending on whether we present a case, they may be there once or twice. But just like anything else, individuals have conflicts, they don't show up. But 5 of the 6 must be present at any time in order to actually present any evidence. Carolyn?
Quick question, does the court mean the judge?
Yes, and I'm going to cover this again in a minute, but a judge is always responsible for one of the when the grand jury is sitting. And so if a particular grand jury is impaneled right now, and I don't know right off the top of my head who currently has it, but the responsibility for selecting and then monitoring the grand jury rotates among the 7 major felony judges. Yeah. Yes, ma'am.
It says any witness may be present at any time, so if you're a witness, you can hear everybody's testimony, whereas the attorney for the target cannot be there?
No, that's misleading the way that's written. In other words, it's just saying who may be present in the context of it.
So when they're called, they'll
Yeah,
be present, but
yeah.
otherwise they would not hear them.
Correct,
Okay.
that's correct, no. Just a witness, the way that's worded is a little misleading, but no, the witness is only there when they're actually testifying.
So is the target not notified if they're not subpoenaed?
No, the target always receives a target subpoena.
Okay.
Could you repeat the questions?
Oh, yes, ma'am.
We get your answer, but we don't necessarily know what the question
The
was.
question was, I can't remember exactly, but the gist was whether there would be times when the target of the grand jury would not receive its subpoena. No, the grand jury target, with very rare exceptions, if there was some reason that we would seek from the court leave to not send a target subpoena because it would disclose or cause perhaps that person to flee. But the sort of case we present the grand jury, we always present the target with a target subpoena. Okay, and so they receive the target subpoena. Sometimes they choose to testify. Other times they invoke their right to not appear and not testify before the grand jury. As I said, the prosecutor is the legal advisor essentially for the grand jury in terms of advising them. There's some standard stock instructions that are read to every grand jury before they hear evidence, and this is one sort of gives a broad outline of what they're called upon to do, which is actually grand jury instruction number 1. The Constitution and the statutes of the state of Indiana make you the judges of both the law and the facts. Although this means that you may determine the law for yourself, it does not mean that you have a right to make, repeal, disregard, or ignore the law as it exists. The following instructions are your best source as to the applicable law in this case. In your investigation of the facts, it will be your determination on whether or not an indictment should be returned. You are to consider all the instructions together. Do not single out any certain sentence and ignore everything else. And as I said, the function of the grand jury is to determine whether there's probable cause to believe the target has committed a crime. Of those of you who have been on jury duty, who sat on a criminal case? Anyone sit on a criminal case? Okay. So those of you who sat on a criminal case will recall that when you're instructed on the burden of proof in a criminal case, an actual trial, it's the state has the burden to prove the elements of the crime beyond a reasonable doubt. And so that is not the standard for a grand jury. A grand jury is determined, is there probable cause to believe that this individual has committed a crime? It's not proof beyond a reasonable doubt. It's the probable cause standard. So as an additional instruction, the grand jury is instructed in this way. The function of the grand jury is to determine whether there's probable cause to believe that the target committed a criminal offense. Probable cause has been defined as the existence of evidence which would lead a reasonably prudent person to believe the target is guilty of committing the criminal offense or offenses here for your review. You should not indict based on your suspicions, beliefs, or feelings if they are not supported by the facts. You should limit your consideration to the facts and law here at issue. So, if the grand jury determines that John Doe, there is probable cause to believe that John Doe has committed that burglary, then they would vote to return an indictment. And for a valid indictment, at least 5 jurors must concur that that is the case. The indictment must be signed by the prosecutor or deputy prosecutor, must be endorsed with the phrase "a true bill," and must be signed by the 4 persons of the grand jury or the 5 members of the grand jury. And our friend Peg thought that putting Harrison Ford up there was pretty cute. Let's talk about some of the practical matters here in Marion County. Number one, there's always a grand jury that has been impaneled. The grand jury typically serves a term of 3 months. And because, again, we don't present many cases to the grand jury, a grand jury might be impaneled and possibly never hear a single case. Or they might hear 1 or 2 cases. Obviously, the grand jury that's just been sitting heard the Broad Ripple shooting case and returned an indictment in that case. In spite of the fact that they are impaneled for a term of 3 months, if there are particular reasons that we would need to extend the term of that grand jury, we can request the court to extend the grand jury for an additional period of time. Our grand juries, the Marion County Grand Jury, by ordinance, also review all police action shootings and in-custody fatalities. So any instance in which there is a police action shooting in which an individual is killed, that matter is presented to the grand jury as well for hearing by the grand jury. As I said before, in terms of responsibility for monitoring the grand jury, that rotates among the 7 major felony superior court judges. That would be criminal courts 1 through 6, as well as Court 20, which is the major felony drug court, Judge Eichholz. So on a 3-month basis, each of those judges will be responsible for, in the first instance, impaneling the grand jury, and then responding to requests for subpoenas and that sort of thing. Jurors are paid a nominal fee. We do provide lunch. That was on the original slide, but I took it off. But we do provide lunch for the grand jurors. And at the conclusion of the work, we provide reports to the court regarding what the grand jury has done. In addition to what we generally refer to as the regular grand jury, by statute, there's the ability to request the appointment of a special grand jury. So as I said, we'll have a grand jury sitting at any time for the 3-month periods. There are occasionally investigations where if we feel it's going to be a little more protracted or there are a number of targets, we will occasionally ask for a special grand jury. The most recent one where we've had a special grand jury involved the investigation which led to the indictment of David Lott Hardy, who was the former chairperson of the Indiana Utility Regulatory Commission. That case is actually, there was an indictment returned, and that case is currently on appeal. But that is an example of where it was kind of a specialized area, a particular topic where we felt that a special grand jury should hear that matter. And so a special grand jury would serve in addition to the grand jury regularly summoned. It has the same powers and duties of a grand jury, and again, the members can serve 3 months or longer if we request an extension of time on that grand jury. The couple of examples of when I was a deputy prosecutor and assigned to the grand jury, there was a state police investigation years ago. Those of you in my age range might recall that there was a state police investigation of multiple counties years ago that ultimately was called Kim Scam. And it involved essentially individuals who were selling industrial chemicals to municipalities and paying kickbacks to get that business in municipalities around the state. And I worked on that case in terms of the Marion County connection with those cases, and there was a special grand jury impaneled to hear the Kim Scam cases. And again, in large part that was because there was going to be lots and lots of witnesses and a lot of documentary evidence, and so it was appropriate to have 6 individuals who could focus solely on that case. Another example of a special grand jury that was called when I was a deputy prosecutor, which I ended up conducting, was an investigation of individuals who were not only from Marion County, but they were from around the state, who were coming to Marion County and essentially preying on runaway boys in downtown Indianapolis. And so again, that was an investigation where the grand jury focused solely upon that particular matter and heard cases involving numerous targets, and ultimately returned indictments against 15 individuals, as I recall, in that special investigation. So again, those are examples as why you would have a special grand jury rather than the regular grand jury. Yes, ma'am.
Is there a difference in how special grand juries are selected?
No. The special grand jury is selected in exactly the same way. They hear evidence in the same way. The law is presented in the same way. Yes?
In some of the cases, particularly like white-collar crime or something like that, that has to do with things that may be a little more intricate in terms of the complexity of it.
Mm-hmm.
I mean, how do you determine the type of juror that would sit and really understand those different levels of, I mean, it's different between shooting and somebody's running a Ponzi scheme.
Mm-hmm.
So how do you?
Yes, and that's an excellent question. Again, that kind of gets to the voir dire process when the individuals are first summoned in. If you've ever been on jury duty, that the questions and our friend from the PD's office and our deputy prosecutors, will be familiar with the process where you can't ask questions directly on the subject at hand, but you can kind of dance around it to get an idea of whether the individuals would have the ability and inclination or have any prejudice already built in terms of the type of case. And so that you would address essentially in the voir dire process, where in the voir dire is the examination of the individuals. And I'm sure those who've sat on the jury, more individuals are called in, for example, than they're going to sit on a 12-person jury, having a regular jury, and you go through the process where those individuals are questioned about their background, their beliefs, and that sort of thing. And so I can't go into the David Lott Hardy, but the IURC, but again, you would want to know individuals' knowledge about political corruption cases, that sort of thing, and ask them general questions. And then at that point, you just kind of make your best guess as to. So what we've talked about, yeah, Carolyn, and I'm happy. We'll obviously take questions at the end as well. So Go ahead.
Well, I get the impression that that when they're during the voir dire process, that they're trying to weed out anybody who knows anything about the legal system. Like the reason I say that is because it seems like, I got weeded out, I think a year ago I think the reason was because, I'm too active in crime prevention.
Mm-hmm. If I'm the defense attorney, I'm probably going to strike you at that point too.
Right. But I also worked at the law school for a couple of years.
Uh-huh.
And now that doesn't make me an attorney, it doesn't even make me a paralegal. I was just, assisting,
Right.
as a secretary.
Right.
So, but I don't know, I just get the impression that they don't want anybody who really knows that much about the system. At least, like, they don't want a police officer. I don't think they would want to.
Yeah, well, I couldn't speak for every attorney, but I don't think I would agree with that. And I got called for jury duty for about 3 or 4 years ago, and I sat on the jury. So either they didn't think I knew anything about the legal system, or they didn't care.
All right.
Okay,
thank you.
I sat on that jury.
Okay.
So what we've talked about here up to now is the state system. In other words, state crimes and how those charges are filed. And again, 99% of the time, we file a charge in state court. It's by way of an information, not by grand jury indictment. Federal system does the opposite. All cases go through a federal grand jury. And so Tom is going to talk a little bit Here's Tom Gankars. He's supervisor, our grand jury supervisors. And before we get to Tom, the question was asked during the break, and I thought it was a good question because I probably didn't make it clear. When we present matters to the grand jury as the prosecutor, we cannot and do not advocate for any particular result. In other words, those of you who sat on a regular jury, obviously you hear opening statements, you hear a final argument in the course of the case. That's not done in the grand jury. The evidence is presented, the instructions are given, but as the prosecutor, we are not allowed and we do not advocate for any particular result. It's up to the grand jury to hear it, hear the evidence, hear the law, and then make a judgment as to whether they believe an indictment is appropriate in those circumstances. Yes, ma'am.
I'm sorry, but I just wondered, by the are you questioning the witnesses?
Yes.
And so your viewpoint doesn't color the questions, or?
Shouldn't.
Should?
And the question was asked, whether in other instances, has the grand jury ever been manipulated? And I'm not talking about here, I'm talking about anywhere. I can't speak to that, but in answer to the question was asked, part of my response was, it would do us no good to manipulate a result, because ultimately, if an indictment's returned, then we have to prosecute that case. And so, either there needs to be a sufficient basis to justify that case or not. And so, again, we don't advocate as would be done in trial at all. As I indicated before we took a quick break, in the federal system, federal crimes is entirely different than state crimes. And Tom is now the supervisor of our grand jury investigators, which is going to be the second part we're going to talk about here in a second. But Tom is, I believe, a 25-year veteran of the FBI. He spent the last 4 years of his career as the assistant special agent in charge of the Indianapolis office, the FBI office. And so Tom's going to give a little overview of the contrast with the federal system, talk a little bit about how information now comes to our office in terms of investigations by the police officers assigned to our office full time, and then you'll be stuck with me again in a second.
Thank you, Mr. Terry. Now I get to confuse you even more. Basically, a federal grand jury, there's a lot of similarities to the state grand jury. Basically, the Fifth Amendment to the Constitution requires that the federal legal system use a grand jury to bring charges against an individual. When it first began, back when the country started, it was for capital offenses and infamous crimes. And as time's gone on, it's been interpreted as far as that an indictment is required for violation of a felony of a federal law. Defendants, and then, as Mr. Curry said, the evidence is presented to that grand jury, and they either vote that there's probable cause to return a true bill or there's no true bill. A defendant usually knows that he's the target of a grand jury investigation. He can waive his right to that indictment and plead guilty or plead to an information of basically the charges, which is the same thing as if it went before the grand jury. The way the system is that the Supreme Court has not made this mandatory for all the states to follow. So, as Mr. Curry's explained, the state of Indiana, that the requirements that they have as far as the number of jurors, what cases they hear, and what's presented does not have to follow the federal law. Basically, what does a federal grand jury do? They're enforcing the federal criminal laws of our country. The composition of that grand jury is 16 to 23 people. As Mr. Curry stated, they come from voter rolls, from BMV data, things like that. Basically, they're chosen from the general public. Somebody asked a question, if I'm an attorney or a doctor or anything like that. Way back, if you look at history, that's basically who sat on the grand juries. Today, everybody from every walk of life sits on a federal grand jury. Basically, just like the state system, when a grand jury is impaneled, they have a foreperson and basically a deputy foreperson, just in case that person's not present during some time the grand jury meets. There's a deputy that can take over. And basically, what that individual is responsible for is to handle all the administrative duties, call for votes, ask questions of people who come before the grand jury, and they administer the oath to witnesses who come in and testify before that grand jury. When a grand jury meets, they need a quorum of at least 16 people for the evidence to be presented. There are two types of grand juries. There's regular grand jury that basically hears all about various different federal crimes. Back probably in the late 60s, they came up with special grand juries. The special grand juries were basically implemented to deal with organized crime type of violations. Usually these are more complex, more involved, and they selected special grand juries, but today they've kind of, that fine line does not exist anymore. They do impanel special grand juries, but they hear all types of crimes too. What's kind of unique, Mr. Curry gave the timeline that a person has to sit on a grand jury. If you're on a regular grand jury, your time serving that is 18 months, and it can be basically extended by 6 months. For the special grand juries, again, it's 18 months, but you can be extended for 6 months 3 different times, so you're talking another 18 months that you could be serving on that grand jury. The reason being is because usually those types of crimes against organized crime take a longer period of time, and you don't want to be presenting all your evidence to this particular jury and then 18 months rolls by and now you impanel a new grand jury, because now you have to represent all that evidence and begin where your investigation has taken you. The one thing is that the information, the grand jury proceedings, there's actually a stenographer that sits in the courtroom and types all the testimony that's given. And again, that information, if a grand jury returns a true bill, all that testimony for the grand jury is given to the defense attorney for him to review, see who testified to what at what particular time. What is their role for a federal grand jury? Basically, they're there to gather the evidence. There's a prosecutor who kind of coordinates things and brings things, schedules the time to present evidence to the grand jury. The grand jury subpoenas documents, physical evidence, and they subpoena the witnesses. And then again, the prosecutor presents that evidence, helps kind of bring along the witnesses, asking questions. And I've sat in numerous federal grand juries, and the jurors have asked questions also. They ask a lot of in-depth, quite difficult questions that have to be answered to the best of your ability. So the federal grand jury system, there's a lot of participation by the individual members during witness testimony and things like that. Typically the witnesses, you'd think that they're only going to be the federal law enforcement officers, the FBI, DEA, IRS, but witnesses in general who have information can also be subpoenaed to that grand jury and have to present testimony there. A lot of times now, the FBI, DEA, we've created task forces where we work in partnership with our local and state agencies and bring them on board. They also can testify in front of the grand jury, even if the FBI adopted a case from the state or local agency, then an officer who began the case, he could be called to testify in front of that grand jury. And then basically what happens is that once the information is presented, the prosecutor basically summarizes the case, or the agent at times comes in and summarizes the case, and the grand jury will deliberate, either returning a true bill or no bill. Unlike kind of the state system, what you have to remember is that just because a grand jury may come back with no bill, doesn't mean that the process is over. Double jeopardy does not apply in that circumstance for the fact that double jeopardy only applies when a person is charged, and according to the federal rules of criminal procedure in Chapter 6, somewhere along there, I can't give you the exact one, but technically until a person, somebody in a trial is sworn in, then they can't be and they're acquitted, you couldn't try them again. But the grand jury system allows basically to go out and gather more evidence and present it before the grand jury to see if there is enough to indict that person. One thing you have to remember is that the federal grand jury does not have anything to do with civil matters that take place throughout the country. It only deals with the criminal aspect of crimes that are committed against the country. Just like the state system, grand jury testimony, the sitting of the grand jury is secret. Usually they meet at the federal courthouse, but it's a room that's isolated from the public area. Witnesses, you may have witnesses scheduled for the next, all morning long. Those witnesses will be placed in separate rooms so they don't know who's testifying in front of them or after them. The reason being is because that witness will testify without fear of retaliation, and it protects that defendant's reputation, because if you don't have enough evidence, that person is not subject to the scrutiny of the public as far as a story leaking or anything like that. One thing you have to remember is that typically, if you're a target of a grand jury investigation, typically a target letter would be sent out to you, but that isn't necessarily true in all circumstances. For instance, if you're doing an investigation against organized crime, if you're doing an investigation against a gang, you're not going to call a guy up or send him a letter saying, hey, John Doe, you're the subject of our investigation, you're the leader of this particular gang. But if a person decides, or they are a target, says, hey, subpoena me, I'll testify before the grand jury. Unlike the state system, that person can be represented by counsel, but counsel cannot be in that grand jury room. It's only the witness himself or the target himself. If he has a question he needs to clarify, he has to step out of the room, meet with his attorney, and go back in the room to answer the question, or not answer the question, or take the fifth, basically. So those are kind of the differences as far as the federal system. Again, all crimes basically that are felonies are charged by way of indictment in the federal system. Like I said, they can charge them with an information. At times, criminal complaints have been filed, but those are usually for the misdemeanor type offenses. Yes, sir.
Does this process ever have to be used for someone that's already in prison, or already in jail, or already detained in some way? So what would differ?
Typically, let's take a violent incident where, let's take a gang, okay? Gang's involved in a drive-by shooting where somebody has lost their life. And the local agency goes out and files charges against that individuals and locks them up. And an investigation is being conducted by a federal agency, and that is a piece of the puzzle to eliminate the whole gang. He won't be charged in federal court, but he is being charged at the local level. So yes, can he remain in jail? Yes, he can. Could he be charged and actually go to trial? Yes, he could, until he gets indicted by a federal grand jury. Because usually the federal grand jury, if we're looking at a circumstance like that, and we're not like this in every case, but you're trying to, just like an organized crime, when you're taking down a family, you want not only the lieutenants and captains of that family, but you want the hierarchy and the leadership. Trying to eliminate that whole threat to the community. Yes?
Explain to me what bill means. You said that they have to get a bill.
Basically, when you come back with a true bill, that federal grand jury determines that there is probable cause to determine that a crime, whatever the crime is, has been committed.
Okay.
And basically, they call it a bill, but what it actually is the charging information signed by the foreperson for the grand jurors, and then it's endorsed by a judge or the clerk of the court, and then that indictment is issued.
Okay.
Yes.
Did you say that the attorney can't be in the room with him while he's giving testimony, but he can go into the room
Yeah, you
and
can-
consult with his attorney?
Yeah, you can consult with your attorney, but he can't be in that room. Proceedings are secret, and they are protected against, self-incrimination, but that's why your attorney is there, but he can't be in the room with you, which is a little different than the state system. Yes?
Can you plead the fifth when you're?
You can plead the fifth. A lot of times, targets aren't even called at the grand jury. Sometimes they already know, their attorneys are saying, well, my client has a plausible story, explanation, and they want to come before the grand jury and explain their side. So yes, they can come in and testify. Any other questions? So basically, you can kind of see the differences that take place between the state and the federal systems. Like Terry said, maybe we should rename our grand jury investigations unit. But the fact is what basically the unit consists of is officers from IMPD, the Marion County Sheriff's Office, and the state police. What we focus on are the white-collar type crimes, more complex crimes that are committed in Marion County. These are your financial crimes. They're the non-violent crimes. But basically, what the bottom line is somebody's trying to get some kind of monetary gain out of the whole fraud that they're trying to commit. When you look at it, a single scam, it can, devastate the community, it can devastate a family by taking their entire life savings. It can cost billions of dollars for investors and companies. Like if you look at the Enron case, that hurt a lot of people financially throughout the country. So basically, and we work all kinds of fraud cases, and everything from telemarketing fraud, internet kind of fraud we're starting to look at. We're trying to expand our purview into that, because a lot of times senior citizens become the victim of these types of crimes through the internet. We're also looking at insurance fraud, mortgage fraud. A lot of times, typical scam of loan origination fees and reverse mortgages that are committed against seniors, the property flipping that takes place in the community. We're looking at all those types of cases. A lot of our cases come through referrals. And what I mean by referrals is that a lot of times the local police departments will contact us and they have investigated a particular crime but realize it's much bigger. Well, we have the ability to take our time because basically what a fraud entails is basically gathering documents, analyzing them, and then presenting them through our probable cause to see if charges are warranted against a particular individual or group of individuals who are committing this fraud. Mr. Curry has done an excellent job as far as reaching out to our other agencies, the Attorney General's office, the State Medicaid office. You can come up here and help me out. Workforce development, as far as them sharing information with us where they have violations that they may not be able to investigate fully, that they bring to our office, and we'll run with them from there. The cooperation has been outstanding. We have brought some cases from workforce development, and that's where I'm going to let Mr. Curry back in and kind of explain some of the cases that have taken place and what's going on right now.
First of all, and Tom made an excellent point going back to the grand jury, and that is the grand jurors are allowed to ask questions and regularly do, and when matters presented before the grand jury. In addition to questions being asked by the deputy prosecutor, the grand jurors then have the ability to ask questions as well. And again, at the risk of sounding like a broken record, it finally hit me, when I was getting ready, how confusing it is that we call the investigators assigned to our office grand jury investigators, because just like most of the cases, the sort of cases I'm going to talk about here, 99% of the time we just file them the same way we file everything else. The officers assigned to our office prepare the probable cause, we prepare the charging information, we take that to a judge, and the charges are filed in that manner. And so we have currently, and this is the way it's historically been, our officers are assigned to the Marion County Prosecutor's Office. Going back to when I was a deputy prosecutor, we had officers assigned full-time to engage in the sort of long-term investigations that Tom made reference to. We currently have 4 detectives assigned from IMPD, including Sergeant Eads, Barbara's son, and father of her lovely 2 granddaughters. We have 2 officers from the Marion County Sheriff's Office assigned to our office, and we have 1 detective assigned from the Indiana State Police. In addition to having those officers, we now have 5 deputy prosecutors assigned full-time to the grand jury unit to work on those sort of cases. We have clearly made white-collar crime a priority, and as I anticipated that once we let it be known that we had the ability and the inclination to prosecute those cases, we'd have more work than we can do. And that's kind of where we are. We will get the work done, but we have new referrals coming in every single day. I know where Tom got the reference to some of his reference to white-collar crime, because I looked at the FBI white-collar crime site today, which had this summary of white-collar crime. Lying, cheating, and stealing. That's white-collar crime in a nutshell. The term, reportedly coined in 1939, is now synonymous with the full range of frauds committed by business and government professionals. It is not a victimless crime. A single scam can destroy a company, devastate families by wiping out their life savings, or cost investors billions of dollars. Today's fraud schemes are more sophisticated than ever. And as Tom said, it's billions and billions of dollars nationwide and involved in white-collar crime. Now, I want to kind of come back to that at the end, just the whole idea of why it's important to prosecute white-collar crime. We'll talk about some of the cases that we've done in the first 2.5 years in office. Thomas Redmond was a former securities broker. He'd actually, his license to sell securities has already been revoked at the point that he perpetrated the fraud that he did. But essentially he defrauded 10 elderly members of his church out of almost $600,000. That matter came to us by way of the Secretary of State's office. The Secretary of State has the authority to investigate securities violations, and so that information came to us. Our deputy prosecutors became involved, fleshed out the additional information necessary to file the charges, including significant long interviews with all the victims, obtaining Mr. Redmond's bank records to determine what he had done with these funds, and that case has been resolved by a guilty plea by Mr. Redmond. Karen Armacost worked for a group of physicians. This matter came to us by way of referral from counsel for the physicians that she worked for, who had the initial information. David Lindsay, one of the detectives from IMPD, worked the case along with Janice Skelton, our deputy prosecutor. Again, kind of similar additional investigation in terms of obtaining bank records. Actually, some of the funds ended up going to Ms. Armacost's sons, as I recall, correctly, which interviews with them as well. Ultimately led to charges. Again, that was almost $700,000 she'd stolen from her employer. That's been resolved by a guilty plea as well. Stacy Sheedy was both an attorney and an accountant, and the information regarding that case first came from an attorney who was involved in the guardianship of an elderly woman, and Stacy Sheedy was the guardian of the estate for that woman, meaning that she had control of the financial affairs. The woman's name was Adair Gardner, Alzheimer's in an extended care facility, and the other attorneys involved in that guardianship became suspicious of what had been done with the funds, came to our office and provided that information. That case actually was assigned to Sergeant Eads and Daniel Harrison, our deputy prosecutor. And so initially the steps in the investigation involved getting the bank records from the guardianship. In going through the checks, Sergeant Eads also found that one of the checks had been written to an estate, to a trust, and determined who the beneficiary of that trust was, approached that woman and found out that Stacy Sheedy was the trustee of that trust, and so pulled the bank records for that trust account as well, obtained information from the beneficiaries of that trust, which included documents that Ms. Sheedy had provided to the beneficiary that and emails indicating that she had taken the funds out of the mutual funds that they were in, which actually was well over $600,000 when she first took responsibility for the trust. She'd taken funds out of the mutual funds and started providing statements to the beneficiaries on something called the Bond Fund of Indiana, and including showing how well that these funds were doing in the Bond Fund of Indiana. You can guess the conclusion. That's there's no such thing as the Bond Fund of Indiana. And the total net, which she had taken, was well over $600,000, or approximately $600,000 from those two. Stacy Sheedy pled guilty to, I believe, 2 counts of theft, felony theft, and she's actually serving an 8-year sentence right now in the Department of Correction. David Reese, actually the theft from that estate was more like $400,000. Based on negotiations, we agreed to plead it to that amount, and he pled guilty as well. Mr. Reese is 72 years old and is a cancer patient, so he actually received an 8-year sentence of home detention from the judge. We actually asked for executed sentence for him as well. So not a very good reflection on my occupation. We've charged 2 attorneys here in the first 2.5 years. We have a 3rd case pending against another attorney for allegedly failing to file state tax returns for 5 years' time. So these are just examples of dozens and dozens of cases we filed in the first 2.5 years. We prosecuted a woman by the name of Sheila Amos. She styled herself as a sovereign citizen, meaning she wasn't subject to the laws of the country and the state. She preyed primarily upon individuals in the Latino community, and through the work of our friend Maria back here, Maria Wildridge, we identified well over 40, 50 victims? More than that. Where essentially Sheila and her colleagues were so brazen that they would identify abandoned properties, go drill out the locks on the doors, put new locks on the door, and take over the properties, and then create very official-looking documents and prey upon naive people that they actually could convey title to these properties. And Sheila Amos had a pretty significant criminal history and went to trial. She's convicted of all counts and is actually serving, I believe, a 32-year sentence in DOC at this point. Another case, yes, ma'am.
Is there a dollar minimum threshold under which something is determined whether it's white collar crime or not?
Not really, and it's a really excellent question, and that for this reason. And in the federal system, they do have thresholds essentially, and it's not a hard and fast number, and not necessarily for white collar crime, but the sort of things they would look at. And so, and it's a pretty high number, you know, whether it's and it's not a hard and fast number, but a lot of instances, if it's not $500,000 or more, they might not even look at it. And as a consequence, if the county prosecutor is not willing to take on those cases, you can go out and commit $100,000, $200,000 scams, and it's going to fall through the cracks. And you know, I'm not here to kick around my predecessor, but I believe that's exactly what was happening in the past, and that's exactly why we made it a priority to get the word out that we're here to prosecute these cases. And as a consequence, that's why we just have cases coming from all kinds of sources, other federal agencies, attorneys, businesses that we're prosecuting. Another case that we prosecuted, another example, you probably recall this, we prosecuted 2 women who submitted fraudulent claims for benefits after the collapse of the stage at the state fair. Those individuals both pled guilty to charges.
I have a question.
Oh, yes, ma'am.
In these fraud cases, do typically the people repay any of the money, or what are they required to do?
Yeah, and it's not uncommon to have a restitution order, and sometimes they have the ability to do it, and they do. Other times they have no ability to do it. In Stacy Sheedy's case, actually, private counsel for the victims there have gotten a judgment against her, and that's going to be good for maybe as much as 10, 15 years when she gets out to try and collect. But the sad reality is just as you would guess. Sometimes they don't get anything. But in the Redmond case, the victims, he had given a small amount back to the victims, restitution, but whether they'll ever get repaid in whole, not likely. A couple other things I want to mention, then we'll wrap it up and we'll ask have some questions. Here's another example of some of the cases we've done in our office. Common wage is something that even a lot of prosecutors don't even know exists. There's a statute that requires in public construction projects that each county will have what's called a common wage committee, which will set the wages that are to be paid on these public construction projects. So one of the cases we've done, I'm going to talk about, involved construction for IPS. And they will set a wage scale that's for unskilled, skilled, semi-skilled, and skilled workers. 3 tiers of wages that are to be paid. And the point of that is to make sure if we're having public construction projects, there's going to be the quality workers on there that you want doing this work, and not some fly-by-night outfit if we're paying our tax dollars to do it. So there's statutes that govern this called common wage, and failure to pay a common wage on public construction projects is a crime. And it became very apparent to me in the course of the campaign that no one was paying attention to this. As a consequence, there are contractors, subcontractors who are routinely cheating on these projects. And the point was, not only are they cheating their employees, who are supposed to be paid amount, but they're cheating the public because they're not getting the quality work amount, and you're really cheating the contractors who play by the rules, because they can't go in and bid on projects knowing that they're going to pay what's required of them and be able to effectively bid against people who are cheating on these bidding. So the consequence, in our first year in office, we received a referral on a case involving a company called White River Mechanical. There was a subcontractor on an IPS job, and in that case, we built a case against them by, number one, obtaining the contracting job documents from IPS. We obtained subpoenas for bank records from White River Mechanical. Ultimately, we got a search warrant for White River Mechanical and went and seized their computers and documents related to what they paid. and developed a case that in fact they were cheating on that job, and White River Mechanical pled guilty to that. That was the first ever common wage conviction in the state of Indiana. And part of what we want to do is send the message that we're watching, and as a consequence we filed the second case. We have other active investigations. It's an area that again has been ignored in the past, and I am proud of our office for pursuing these sort of cases. Unemployment insurance fraud cases. We started having conversations with workforce development. That's the state agencies responsible for unemployment compensation. And I was going to mention in a minute, but I'll mention it now. They estimate that last year alone there was $13 million in fraudulent claims for unemployment compensation in the state of Indiana. And so as a consequence, and in addition, they, in conversations with their office and general counsel there, they were frustrated that they could not get prosecutors to pursue these cases and get anyone to listen to them. So as a consequence, what we've done is build a partnership with Workforce Development, where they are actually funding a position for us in our office, where we have a deputy assigned full-time to look at these cases. And we announced the partnership in February. Since that time, we have filed almost 20 cases, representing about $750,000 in fraudulently obtained benefits and penalties. Part of the understanding with Workforce Development is that they had meaningful cases in other counties that originated essentially in other counties in the state of Indiana that they couldn't get the local prosecutor there to look at for one reason or another, that we would potentially prosecute those cases as well, because we could exercise jurisdiction in Marion County to the extent that claims get processed through the Workforce Development Office right here in Indianapolis. And so as a consequence, 3 of those cases that we are prosecuting actually originated out of Elkhart County, where the prosecutor declined to pursue the cases.
What happens if it is proven that it is fraud? I mean, what is it, like prison sentence?
Potentially, depending on the criminal history. I believe there's 3-4 of the cases that where they've entered guilty plea, and in those cases, what the plea agreement provides is that they're going to repay the fraudulent benefits and penalties in full as part of the plea agreement. And if they don't, then they're subject to potentially going to the Department of Corrections. So,
and their unemployment is ceased.
Yeah, oh yeah, that's been ceased. Yeah, yeah. Because the basis of the claims in virtually every instance is what we establish is they're claiming unemployment benefits, but they're actually working. And so that's the basis of the fraudulent claim in the first instance. And actually, just one other mention about this is that what we've done with Workforce Development has gotten such notice that the Commissioner of Workforce Development actually was asked to testify about a month ago before a federal congressional committee about our partnership here and how we're pursuing these cases. We are also in the process, and Tom alluded to our relationship with other agencies. We essentially have a similar working relationship, task force relationship with the Indiana Department of Revenue and the AG's office to more aggressively pursue criminal tax cases. We are doing the same in terms of the Attorney General's Office of Medicaid Fraud. And so we have a lot of work on our hands, but it's exactly what we set out to do. And my last point is this, is that not only is white-collar crime something that is potentially devastating to families, to businesses, it's billions and billions of dollars. As I said, workforce development alone, unemployment comp, is $13 million fraud estimated last year alone. And so it's clearly important to me and a priority for our office to prosecute these cases. But I think there's an additional intangible aspect to prosecuting these cases and what happens if you don't prosecute them. And that is that if you take seriously street crime and run-of-the-mill day-to-day crime, as we all should, and we do, but you ignore white-collar crime and those who would scam their family and friends out of money, it only reinforces the fact that some believe there's a double standard in the system. And so there should not be a double standard. There's not a double standard. And to me, that is just as important as the fact that we send these people to prison, is to send the message that there's not a double standard in our criminal justice system. With that, I'm happy to answer any question you might have. As I said, the crime lab stuff's going to be really interesting. Yes, Pastor Gerton.
I was curious, you mentioned that you all are receiving referral almost every day. I'm curious as to where, are these citizens or police or attorneys or, I mean?
All the above.
Okay.
Yeah, and as a practical matter, clearly the police department over the years, IMPD, for example, has a financial crimes unit, and so they'll look at some of these things as well. But we have more resources, we have more contacts, and so sometimes they might send us a case, other times something might come to us, and we think that's something maybe the financial crimes unit, and so that will come. But yeah, I mean, just like Karen Armacost was a matter of their private attorney doing some initial looking at what had occurred. It appeared that she had stolen from his client, the attorney's client, the group of physicians, and so he then contacted our office. So it can come from businesses, attorneys.
Is there a pecking order?
A pecking order, what do you mean?
Is there like, well, if it comes from an attorney that gets in this file?
No,
That's gonna get looked
no,
at before
no.
the police are gonna look-
It's just a matter of determining, is this something that's more appropriate for us or for someone else? In most instances, the stuff that gets to us, we're gonna look at it. What you recall our general?
Yeah, basically, we currently have ongoing investigations where citizens have called and complained that maybe they contracted with a company to provide some kind of service repair on their home, and that either wasn't completed, it was done wrong, whatever. A citizen will call us. We'll look at that information. We just don't say, call the Better Business Bureau. I mean, we'll look at that to see what activity took place, who was the contractor, what took place, and are there other victims out there? The majority of times we find that there's numerous victims in the community who have been subject to some kind of fraud perpetrated by this contractor, and we conduct the full investigation, trying to identify as many victims as we can.
Yes, sir, Mr. Boyd.
So are you saying that if you have a situation like that, then you should contact the prosecutor's office rather than the Better Business Bureau?
Yeah, I mean, if you think it's crime, I mean, I certainly, or even contact the IMPD in your district, and they can get the stuff to us as well. But yeah, I mean, anytime you feel you've been victimized, just reach out to any number of agencies, and again, you can contact our office directly, and it doesn't mean we're going to take every single case. As Tom said, we're not going to ignore you. If it's not something we're going to undertake a criminal investigation on, we can get you to the appropriate agency as well.
Oh, well, in the federal grand jury, when the principal, I'll say the principal company or group or whatever is out of state, but you have things going on that's feeding down from their state down to our state. I'm thinking like in real estate, okay? Who takes charge of that? Does our federal people have to relinquish back to the state where the perpetrators are, or can we take it from?
Not necessarily. Tom, you can join in as well. No.
Basically, the nice thing about the federal system is if it's a multi-state fraud being committed by a company, and they targeted numerous states, usually whatever jurisdiction the prosecutor's office, federal prosecutor, is initiating an investigation. I mean, they usually pursue it. They'll call the other jurisdictions and say, hey, we're going to be investigating this particular crime. So,
So it just depends on
jurisdiction.
jurisdiction.
What's nice about the federal system is you're not limited by borders.
Right.
Okay.
And then if we have those issues as well, then it makes it easy for us to reach out to our federal partners. we have a great working relationship with the U.S. Attorney's Office and the federal agencies. And we did to begin with, but now with Tom on board, it's enhanced even further with his contacts, so.
Thank you.
If anyone has a question, but Kavana, Annie, was there something else we needed to do? Go ahead, I'll answer your question too.
When you mentioned that, of course, the white collar crime isn't victimless, in fact, it seems like it would be just the opposite. So you mentioned Enron, look at the financial collapse was in 2008 or so, and that actually affected trillions of dollars, people all over the planet.
Absolutely, absolutely.
And because social economic status and crime is related to people being able to earn money for workable wage and that kind of thing, that would harm everybody maybe for decades. I mean, enormous amounts of.
No, you're exactly right, and the ripple effect of a lot of these things is that you're exactly right. Sort of the cases we put up there, Karen Armacost, everyone said, well, the physicians, who cares? Well, the ripple effect that goes on and on and on, and Tom Redmond, he preyed upon, church members who were over 70 years old, taking significant life savings from those individuals. Yes, ma'am.
I got a question. Who is in charge to investigate identity theft?
Well, again, that could be any number of agencies, and depending upon the magnitude of it, what happened, it could be our office, our grand jury investigators, it could be IMPD, it could be a federal issue, because it could constitute a crime under both state or federal law, but depending on the circumstances. But we actually, Sergeant Eads actually just prosecuted a case where an individual had used a boy's social security number, I forget how long, over 10 years.
Over 10 years.
Yeah, so he created all kinds of, he'd used the social security number of this young boy and created enormous problems for this boy, and then finally Eric was able to identify who it was, and we charged him, and the boy was able to get a new social security number, and the suspect's in jail.
What happened with the victim knows that person lives in California. Marion County, she lives in Marion County. She talked to IFPD and she gave all the information, but nothing happened after that. So what are the regular procedures in that case?
Yeah, and I don't know who you talked to, but I would encourage her to contact our office, and then my sense would be if there was anything to do, then it'd have to be done in California, potentially.
Yeah, because they have, she find out when she get her credit record, and there was a house was bought, there was a loan for the house, there was a bunch of credit that she never opened because she never was in California.
Right.
But it's been open all kind of credits with her name and her social security.
Yeah, I was trying to think who the best person to give. If you could have her give that contact information to Annie, that's Annie back there.
Okay.
And then Annie can get it to us, and we'll follow up. Okay. I think Kavana had something else.
And let's give another round of applause